Hello, everyone, and welcome to today's seminar. Just to start off with a bit of housekeeping, this is a pre-recorded webinar and it will last for approximately 1 hour. By way of introduction, I'm Robert Brothers, a senior associate in the litigation team here at Myerson, and I'm joined today by Jack Ramsden, who's an associate in our insolvency and restructuring team. If there are any questions arising from the end of this session, please feel free to get in touch with us directly, and our contact details are shown on the last slide. By way of brief agenda, we'll be covering the following topics. Firstly, incorporation of contractual terms in commercial contracts and the legal principle of the Battle of the Forms, and some of the key case authorities in this area. Some practical steps you can take to ensure that your contractual terms prevail, why contractual terms are so important, and specific clauses that you might look out for. And finally, retention of title clauses and the impact where the buyer becomes insolvent. So to start us off, let's consider contractual terms and conditions. In simple terms, these are the agreed upon terms that set out each party's rights, obligations, and risks when they enter a contract. A cornerstone of the English legal system is that generally the contracting parties are free to contract with each other on whatever terms they wish, and the courts generally don't interfere with that. So what you tend to find is that many businesses will have their own set of terms and conditions, which they will want to apply to the contract. However, if the parties each have their own unique T's and C's, there can at times be some ambiguity about whose terms will apply. So let me take you through a simple example. You're contracting with a supplier to buy goods. You submit a purchase order to the supplier attaching your standard terms of business. The supplier sends you an acknowledgement for the purchase order attaching their terms of business. The goods are delivered, the supplier sends an invoice, and so far, so good. However, what if something goes wrong? Say there's a delay in the delivery of the goods, or the goods are defective. The causes of action against the supplier will be dictated by the terms and conditions governing the parties' contractual relationship. But the question here is whose terms will apply. And the difficulty that we have in this example is that both parties have sent to each other their terms and conditions, and the supplier will likely seek to argue that their terms apply, since these will usually be more favorable to them. And equally, the buyer may seek to argue that their terms apply for the same reason, and this can result in a stalemate, which is commonly referred to as the Battle of the Forms. Fortunately, the courts have set out guidance on the Battle of the Forms and how to approach that. The traditional approach is the last shot rule, namely the last set of terms sent before performance of the contract usually prevail. We have the classic example in the case of BRS versus Arthur Crutchley Limited. The claimant here, BRS, delivered a consignment of whiskey to the defendant, Arthur Crutchley Limited, who provided commercial storage solutions. On delivering the goods, the claimant's driver handed a note to the defendant, which stated that the claimant's standard terms governed the contract. However, the defendant then stamped the note with the message received under the defendant's conditions. The goods were then handed over. The court in this instance found that the defendant's terms prevailed. The defendant's stamp was effectively a counteroffer, and therefore the defendant was found to have fired the last shot before performance of the contract. However, since the BRS case, the courts have tended to adopt a more nuanced approach, and the court will look at the full exchange of documents, the conduct of the parties, and whether there was any express agreement to any documents, and whether any documents were signed. So let's take another example. In Butler Machine Tool Co. Limited v. XLO Corporation England Limited. The sellers here offered to sell machinery to a buyer subject to their terms and conditions, which contained a price escalation clause, allowing it to increase the price of goods after the contract was concluded. The buyers placed an order for the machines, saying that they were buying subject to their own terms and conditions, which, as you might expect, did not contain a price escalation clause. The buyer's order contained a tear-off slip with a signature box and stating that the sellers accepted the order on the buyer's terms. The seller then signed the tear-off slip, sent it back with a letter to the buyer saying that they were entering into the contract in accordance with the terms of their original offer. So what do we think? If we apply the last shot rule in the BRS case, it looks like the seller's terms apply since they fired the last shot by sending the letter to the buyer saying that they were entering the contract based on the seller's terms. However, the Court of Appeal was not convinced by that argument. The court found that the signed tear-off slip was an acceptance of the buyer's offer to buy the goods on their terms, and that was the point at which the contract was formed. The tear-off slip, which was signed by the seller, was the decisive document in this case, and it did not matter that the seller later fired the last shot. So let's take a final example. The case of TRW v Panasonic Industry Europe GmbH. In this case, Panasonic sought to rely on a jurisdiction clause contained in its terms and conditions, and TRW sought to rely on a different set of terms and conditions which didn't have the jurisdiction clause. TRW previously signed Panasonic's terms, which said that they applied to the entire business relationship unless different conditions were expressly confirmed in writing. The words used included conditions of the buyer diverging from our terms and conditions shall not be valid, even if we have effected delivery or rendered services without reservation. So some years after signing the document, TRW purchased goods from Panasonic, and the terms of TRW's purchase orders did not include a jurisdiction clause. The goods were defective, and TRW argued that its purchase orders were the last documents sent before performance took place, and they govern the contract in accordance with the last shot rule. The court said no, and ruled that Panasonic's terms prevailed. TRW had signed Panasonic's document, which expressly stated its terms would govern any future business relations unless alternative terms were agreed in writing. In essence, TRW had agreed that the first shot would govern the terms of its contractual relationship with Panasonic, and it did not matter that they sent to Panasonic their terms and conditions when placing future orders. And arguably, the most persuasive evidence in this case was the document that was signed by TRW at the commencement of the contract. This was the only time one of the parties had signed something which referred to the other side's terms and conditions, and the terms of the document were clear and unambiguous. They could not be varied without express agreement from both parties. So, in summary, the last shot rule is a useful reference point, but it does not always determine whose contractual terms apply. The documents as a whole need to be considered. The presence of a signature is extremely important in determining when a contract is formed, and agreed terms which say that these can't be varied without express agreement are less likely to fall victim to the last shot rule. And the key thing we want you to take away from this session is to be alive to what terms govern your contracts. It's very dangerous to assume that your terms automatically apply, even when it may seem obvious. And if you don't win the battle of the forms, you could be stuck with the other side's terms, which could put you in a less favorable position if a dispute arises further down the line. It's usually always better for your own terms and conditions to apply rather than someone else's. And here's some practical tips just to make sure that that happens. Firstly, front load your terms, send them the quotes, purchase order forms, and acknowledgements. Make them accessible on your website and bring that to the attention of the other party from the outset. And if your terms are contained on your website, make that clear and include details of how to access these, for example, via a website link, and make sure that that link works. Expressly reject the other party's terms if you don't want them to apply to the contract, and make it clear that you're not agreeing to their terms before the contract is entered into. Don't rely on the other party's silence as an acceptance of your terms. Use clear cover notes or contract letters to set out whose terms apply to the contract. If possible, secure signatures on key documents. And finally, consider including clauses that say your terms override other terms or attempts to vary the contract unless agreed in writing, like in the Panasonic case. So that's the battle of the forms. Let's consider the contractual terms themselves. These are obviously extremely important because they're the legal framework that keeps everyone clear on what's expected and determine things like payment terms, delivery obligations, warranties, liability limits, and how disputes will be resolved. So let's take a look at some specific clauses you might want to be aware of when either negotiating a contract or agreeing the other side's terms. Limitation and exclusion of liability clauses. These are designed to limit the party's exposure to claims and risk if something goes wrong. In simple terms, it sets boundaries of financial risk by capping or excluding certain types of claims or loss. And typically, you'll see clauses that limit liability to the contract value or overall fees paid for goods or services, and often consequential losses or loss of profits are excluded. That means that even if a buyer, say, suffers £100,000 worth of losses, if the cap is £50,000, then that's usually the maximum that they can recover if there is a breach of contract. And for many businesses, that creates certainty. It prevents relatively small contracts from turning into massive unexpected liabilities. And it also allows parties to align insurance cover and negotiate risks up front rather than leaving them open-ended. And there are certain types of loss for which you can't exclude liability, such as liability for death or personal injury or fraud. And also under the Unfair Contract Terms Act, limitation of liability clauses need to be reasonable, and the courts will apply that test and look at the parties' bargaining power, whether any caps are proportionate, and the parties' respective insurance cover. Next, we have force majeure. This is a provision in a contract which excuses or suspends one or both parties from performing their obligations when extraordinary events occur which are beyond their reasonable control. And the scope of events might include natural disasters, war, terrorism, civil unrest, strikes or industrial action, government actions or restrictions, or epidemics or pandemics. So, for example, the COVID-19 pandemic. This isn't an exhaustive list by any means, and the parties are free to negotiate what might constitute an extraordinary event. For example, manufacturers facing strict delivery deadlines for the supply of goods might want to protect themselves from liability or claims for breach of contract caused by events outside of their control, but which halt production, such as shipping delays, port closures, strikes, for example. Uh, if a force majeure clause is triggered by an applicable event, the consequences could be temporary suspension of obligations, extensions of time for performance, or the right to bring the contract to an end if the event continues for a specified period of time. And importantly, force majeure is not automatically applied to a contract under English common law. So it needs to be expressly included in a contract to apply. Otherwise, parties might have to rely on a narrower doctrine known as frustration of contract, which is generally much more difficult to establish. Next, we have liens over stock. Some contracts might contain terms granting one party the right to retain goods or stock until payment of a debt. This is known as a lien, and it's generally seen in contracts which involve carriers, freight forwarders, and warehouse operators. And they tend to rely on liens because they deal with multiple shipments with tight margins and clients who might default on payment. So, for example, you might have a freight forwarder arranging delivery of goods for a customer, but they've not been paid their charges. If there's a contractual lien, the freight forwarder might exercise that to hold goods in its warehouse until the customer pays the outstanding charges. There's two types of lien. A particular lien, which provides the right to hold goods only for the charges directly related to those goods, and a general lien, which is a much broader right to hold goods for outstanding debts by the same customer, whether or not those relate to a particular shipment. And just a word of caution here, exercising a lien can backfire. A lien only applies where the contract expressly provides for it. And even where that's the case, you should be very careful when exercising a lien to ensure that it's validly done. Otherwise, you could expose yourself to claims for wrongful interference, or claims for set off or withholding charges, or even claims by third parties. Next, warranties. In certain manufacturing and supply contracts, you might find warranties, which are contractual promises about the goods, materials, or services. They usually cover things like the goods conforming to certain technical specifications or samples. They're of satisfactory quality and fit for purpose, free from design defects, and the supplier having good title and the right to sell the goods. A breach of warranty won't usually give the buyer the right to terminate an agreement, but it can give it the right to claim damages. And things that you should look out for are what are the warranties intended to cover. Generally, the more specific, the better, as the parties might have a different interpretation of what amounts to expressions such as fit for purpose or satisfactory quality. How long do they last for? Are they aligned with product life cycles or industry norms? For example, 12 to 24 months from the date of delivery. Notification requirements. Defects usually have to be notified within a set period of time of discovering the defect, and require the complainant to set out in detail the basis of any warranty claim. Notification clauses are strictly enforced, and missing a deadline or submitting a defective warranty notice could mean losing the right to bring a claim. And finally, what are the remedies for breach? Commonly, this will be a repair, replacement, or refund, but you might need to check the terms carefully and watch out for attempts to limit liability, for instance, capping the damages at the contract price or simply replacing the goods. Also check whether other forms of loss are excluded, such as consequential losses caused by defective goods, which in some cases can be significant. Next, entire agreement clauses. An entire agreement clause is a provision that states the written contract represents the whole agreement between the parties. The purpose here is to provide certainty of terms and to prevent claims based on pre-contractual statements when terms are being negotiated or alleged collateral contracts. So you might have a clause which says this agreement constitutes the entire agreement between the parties and supersedes and extinguishes all previous agreements. You might also see entire agreement clauses which go further than that and include non-reliance statements, which exclude claims for misrepresentation. So claims based on any representations which are not expressly set out in the contract. So that's worth looking out for, because if there's a representation being made to you in connection with a contract and you think that that's important, then you might consider whether it needs to be expressed as a warranty in the contract. Otherwise, the entire agreement clause might block any claims for misrepresentation. And finally, we have governing law and jurisdiction clauses. It's important to check what law governs the contract and which court has jurisdiction to hear any dispute arising from it. This is important where the contract involves the delivery of goods or services overseas. So if you're based in England, you'll likely want to ensure that you can bring a claim there rather than in a foreign jurisdiction, which might involve unfamiliar procedures, higher costs, and unpredictable outcomes. So that's the end of my section. I hope you found that useful. I'm now going to pass you over to Jack, who is going to discuss retention of title clauses. Thanks, Jack.
Thanks, Rob. Hello, everyone. I am Jack Ramsden. I'm an associate in the Insolvency and Restructuring team at Myerson. I will now be speaking about retention of title clauses and the impact upon such clauses where the buyer of goods becomes insolvent. So, what is retention of title, or ROT, as I will refer to it in this presentation? So the general legal principle is that legal ownership or title to goods passes to the buyer when a contract is made, unless otherwise agreed. This is found in sections 16 to 20A of the Sale of Goods Act 1979. So an ROT clause, or a revalpa clause, as it is sometimes known, is a provision in a contract which purports to allow you as the seller to retain your title to goods which we have delivered to the buyer until such time as the buyer has paid for them in full. The purpose of an ROT clause is to give you as the seller of goods priority over secured and unsecured creditors of the buyer if the buyer fails to pay for those goods. And the aim of the clause is to allow you to reclaim possession of the unpaid goods. This, in part, is to protect against the buyer's insolvency, as if the ROT clause is effective, the goods in question will not form part of the buyer's insolvent estate, and so cannot be used to satisfy the claims of the buyer's secured or unsecured creditors. Now let's look at the different types of ROT clauses that can be used in contracts, including their intended purposes and their associated pitfalls. The different types of ROT clauses include a basic clause, an all monies clause, a proceeds of sale clause, and a mixed goods clause. The starting point for ROT is the basic clause. So this can be used on its own, or it can be coupled with one or more of the advanced types of ROT clauses. A basic ROT clause provides that title to goods is retained by you as the seller until you have received payment in full for those goods. For this clause to be effective, both legal and beneficial title to the goods must be retained. A basic ROT clause should also be supplemented by standard contractual clauses that include the following. So firstly, a right for you to possess the goods, either upon a specified event, which is usually non-payment, or at any time. A right to prevent the buyer from selling or using the goods. A right for you to enter the buyer's premises to repossess the goods. And, where possible, an obligation on the buyer to store your goods separately to theirs, mark them as your property, and allow you access to the buyer's premises to verify that all of that has been done. The next type of ROT clause to consider is an all monies ROT clause. This is where you would retain ownership of the goods supplied until the buyer has paid for those goods and all other goods supplied by you. A key benefit of this clause is that it avoids the need to reconcile specific goods at the buyer's warehouse with specific unpaid invoices. The third type of ROT clause to consider is a proceeds of sale clause. This enables you to assert rights in the proceeds of sale of the goods by the buyer to secure recovery of the purchase price of the goods. And the final type of ROT clause to consider is a mixed goods clause. So this type of clause can be used where you are selling goods for use in a manufacturing process. For example, you are selling components rather than finished products. And it is used where a basic ROT clause may be insufficient on its own. The case law here is complicated, but essentially it distinguishes between goods that maintain their identity, which would generally result in the seller's title to those goods being retained, and goods that lose their identity in a manufacturing process, which would generally result in the seller's title to those goods being lost. An example of where goods retain their identity and where a basic ROT clause was effective is the case of Hendy Lennox and Graham Puttick, where diesel engines supplied by the seller were used in diesel generator sets. Now, an example of where goods lose their identity, and therefore where a basic ROT clause was ineffective, is the case of Borden and Scottish Timber Products, where the resin supplied by the seller was used in the manufacture of chipboard. Therefore, the use of a mixed goods clause together with a basic ROT clause would enable you to assert rights of ownership in any new product resulting from the manufacturing process. However, an important point to note is that in respect of an all monies ROT clause, the courts have held that it might result in the creation of a charge in favour of the seller, and in respect of proceeds of sale and mixed goods ROT clauses, the courts have held that those clauses will almost certainly result in the creation of a charge in favour of the seller. Why is that important? Well, any such charges would be void against any liquidator, any administrator, or any creditor of the buyer, unless they are registered at Companies House within 21 days of creation, in accordance with the relevant provisions contained in the Companies Act. Although it's possible in theory, registering a charge at Companies House for all sales contracts that contain relevant ROT clauses is unlikely to be practical and unlikely to be a realistic option. Therefore, all monies, proceeds of sale and mixed goods ROT clauses should be separated out from other types of ROT clauses in contracts, in case they are deemed invalid for lack of registration as a charge. So next, the enforcement of ROT clauses can be difficult in practice, as they are prone to disputes, particularly in a manufacturing context, and particularly once the buyer of the goods has entered a formal insolvency process. By way of context, the most common insolvency processes that occur in respect to the buyer company are administration and liquidation. In those processes, an insolvency practitioner will be appointed as an administrator or liquidator as appropriate, and they will deal with the administration of the insolvent estate of the buyer. That ordinarily includes the insolvency practitioner identifying and then realising the assets of the buyer company for the benefit of its creditors. So let's now consider some of the key factors regarding the effectiveness of ROT clauses. The following factors that I'm about to discuss apply to both insolvency and non-insolvency scenarios. So an ROT clause must be properly incorporated into the contract between you and the buyer to be enforceable as a contract term. An ROT clause must also be drafted clearly and not too widely, or else it may be deemed void and therefore useless, especially in an insolvency scenario. An ROT clause may be ineffective if its operation is inconsistent with the overall trading relationship between the parties. So, for example, an all monies clause is likely to be ineffective in the context of an agreement between the parties to supply finished goods for immediate resale, as was the position in the case of Sandu and Jetstar Retail. So next, a basic ROT clause alone will be ineffective for goods that cannot be identified or are unidentifiable due to being mixed or processed with other goods, as I've already touched on. Also, as I've already discussed, and if an all monies, proceeds of sale or mixed goods ROT clause is used, then it is likely that the clause will give rise to a charge in favour of the seller, and that charge will be unenforceable unless it is validly registered as a charge. ROT will also be of little or no practical benefit where the goods supplied are perishable or have a low scrap value. And finally, there is a potential limitation on ROT found in Section 25 of the Sale of Goods Act 1979. That section allows a buyer in possession of goods to pass effective title to the goods to a third party who is acting in good faith without notice of the original seller's rights, even though the buyer has not yet obtained title to those goods. So therefore, even if you have the benefit of an ROT clause, you could nonetheless lose title to your goods if the buyer wrongfully disposes of the goods to an innocent third party. So next up, the following factors apply only in insolvency scenarios. Where a buyer enters a formal insolvency procedure, you cannot generally enforce an ROT clause without the consent of the court or the office holders, as the case may be. And that is found in Section 233B of the Insolvency Act 1986. In a scenario where the buyer of goods is a company that has entered administration, the consent of the administrator or the permission of the court is required before the goods can be repossessed. This prohibition also applies during any interim moratorium in administration. For example, that would include where a notice of intention to appoint an administrator has been filed by a qualifying floating charge holder. Also, if the buyer is subject to a moratorium under Part A1 of the Insolvency Act, you may also not repossess goods in the buyer's possession without the permission of the court. As you can see, there are various limitations on exercising ROT. The area has generated a changing body of case law on a relatively frequent basis. Therefore, the review of ROT clauses is a particularly important aspect of the overall review of standard terms and conditions of trade, which you should be carrying out on a regular basis. In light of the limitations discussed, ROT clauses should be used in conjunction with a proper credit control system and not as a substitute for it. On that basis, you should ensure that you know the buyer, and you should keep accurate sales and delivery records relating to all transactions. You should, as sellers of goods in manufacturing, also consider obtaining the following, particularly where there are doubts as to the financial standing of the buyer. Firstly, consider obtaining upfront payment from the buyer where possible. Secondly, reduce the period and/or amount of credit allowed to the buyer. Thirdly, consider obtaining trade credit insurance. Further, you should also consider taking alternative forms of security. So that may include bank guarantee or a letter of credit, or even personal guarantees from the directors of the buyer company. And finally, you could consider requesting some form of deposit or fund from the buyer that is set aside, which can be used if the buyer faces financial difficulty. If you have the benefit of an ROT clause and the buyer enters into a formal insolvency process, then the onus is on you to take action. Here are some practical tips to assist you in that scenario. Firstly, you should contact the insolvency practitioner, for example, the administrator or the liquidator, as soon as possible, and put them on notice that you have a potential ROT claim. You should provide the insolvency practitioner with as much information as possible in relation to your ROT claim, which will enable them to identify the goods in question and the basis of your claim. That information could include the contract, invoices, delivery notes, and any information to assist with identifying the goods in question. You could then negotiate with the insolvency practitioner, if that is necessary, with a view to being able to reclaim possession of the goods. If that doesn't work, then you could consider litigating and issuing court proceedings for recovery of the goods, again, only if necessary, and having first taken appropriate legal advice. Where goods are sold by a receiver, an administrator, or a liquidator, which were clearly identifiable as your goods and they were subject to an effective ROT clause, then you may have a possible claim for damages for conversion against that individual personally. Whilst the threat of that claim could be used as commercial pressure in an attempt to achieve a monetary settlement, it would be difficult to launch a successful claim in those circumstances. So, in summary, specialist advice should be sought in relation to the inclusion of ROT clauses in contracts, and you should look to put measures and protections in place in addition to ROT clauses to secure the recovery of the purchase price of your goods. In the event that a buyer does become insolvent, then you should act quickly and you should seek specialist advice if required. Thank you. I hope that was useful, and I'll now hand back to Rob.
Thanks very much for that, Jack, and thanks everyone for joining us today. I hope that's given you a clearer understanding of the importance of contractual terms and what to watch out for and how to win the battle of the forms, and also for planning for insolvency events when it comes to retention of title issues. If you're dealing with a contract dispute, or just want your standard terms reviewed, or if you've got any questions generally, please feel free to reach out to us directly. And thanks for watching.